And one of the things that I do as the claims advocate and the broker representative with the clients, such as someone like Diane, if she had been here, when the policyholder says they've got situations that they're not sure that they're claims, that might lead to a claim, but somebody, either they or someone in their organization, has decided they really ought to notice the insurance carrier, and how do we do that? And what's the effect of that? Is this going to affect my renewal? Is this going to affect claim handling? What is going to happen when I tell them about this particular situation? And one of the first things you want to determine, and the other panelists have covered this, is, first of all, is it a claim at all? Because sometimes people come up and they say, I've got a potential claim, I've got a circumstance, and lo and behold, it's really an EEOC charge that is a claim. Or it's really something, when you look at the demand letter, it is a claim. And so you want to make that determination and help them understand that first, because obviously if it is a claim, these provisions aren't going to apply, and you're going to be looking at the claim provisions that we've already discussed. And that's a very important distinction, because there are other ramifications that come from that. And I have seen a lot of insureds make that error where they believe something is just a circumstance because that's the terminology they use, or they call it potential because it's not a lawsuit. Even though it does meet the policy's definition of claim. So pay attention to that first before you turn to whether it falls within these notice of circumstance provisions that we have. But say it's not a claim, it doesn't meet the definition. Policyholder really wants to get this information to the carrier. They're going to be talking to the carrier, underwriting. They're sure that the carrier is going to have something to say about it. And you've got to look again at the policy language. It's very important because there are some nuances and differences between the different circumstance provisions. And the circumstance provisions are going to give you the specificity that each carrier requires, which has been alluded to previously. It's very important. And I call it the who, what, why, where, when, and how. You have to be able to say that in order to have your notice of circumstance accepted. So you look at the different prongs of the circumstance language. The first part is during the policy period or during the discovery period, if the discovery period is allowed. Not all policy provisions allow notices of circumstance during the discovery or extended reporting. But during that time, whatever is prescribed, that's when the organization or insured becomes aware of the circumstances which may reasonably be expected to give rise to a claim. And you have to make some determinations. What are the circumstances that you're aware of? What do you know about them? Are these circumstances that can reasonably be expected to give rise to a claim against an insured? If they are, you've met the first set, and you go on to what the form of your notice should be. You give written notice, and you have to talk about the circumstances, the wrongful act allegations you anticipate, the reasons you anticipate the claim, dates, persons, entities, and all those things have to go in your notice and be reported to the carrier in order for a later breaking claim to be considered made at a time in this notice and hold the policy period for that. And this is pretty standard, what you would call the 7C if you talk about the AIG/Chartis language that gives rise to the claim. One point on writing up these circumstances, it is very important, in my view, that you're not making admissions. That you don't counsel your insureds to say, absolutely, this wrongful act happened. Because maybe it didn't, and maybe you're going to a defense of your claim in litigation. You want to be very careful to structure your notice so that you're not making an admission against your interest when you turn in that notice. You're going to talk about what kind of allegations you expect and what might happen, but you're not going to actually make the admission that there was indeed a wrongful act, because that would probably go to the heart of the defense of your claim. Going back to a moment for the situations, and Charlie can kind of talk about what will happen in the renewal. You might be coming up on renewal. You're going to talk about what kind of changes you expect at a renewal. Are you changing carriers? Are you going to have different provisions, different definitions, terms and conditions that it might be a claim under one situation, one policy, and not under another? Are the carriers looking to put a specific exclusion on the policy for whatever this particular event or situation is? Is it going to be on a new policy? Is it going to be on new limits? Is there going to be a warranty? All those things kind of come into play when you're deciding as a policyholder whether it's appropriate to give the notice of the circumstances. And one other thing that did come up in the earlier panels, say you have a suit or something that isn't a claim because it doesn't involve the right wrongful act, it doesn't involve the right parties, but as an insured you kind of have a sense that this is probably going somewhere else. The plaintiff didn't frame it very well, it's going to get amended. And that will probably change such that it is going to fall within the parameters and the insuring clauses of the policy. Maybe you want to consider giving the circumstance there and